Welcome to The Debate. Welcome to the Tejswi IP Show. In this podcast, we dive into the world of intellectual property like patents, copyright, trademark, geographical indication, design. Also analyze the recent event in IP world. Today, we're unpacking a high-stakes reality that we navigate daily here at Tejswi IP. That is the massive vulnerability of foreign brands expanding into the Indian market. Time and time again, we watch global corporations cross our borders, treating intellectual property clearance as a simple checkbox exercise. They assume whatever worked in Europe or North America will just seamlessly translate over here. But as we know from defending these exact architectures, that approach fundamentally fails. India isn't a hostile market for foreign brands, but it is an intensely procedural one. Treating legal architecture as basic paperwork leaves companies incredibly exposed.
Yeah, you hit the nail on the head regarding that assumption of seamless translation. The Indian market is incredibly dynamic, but it possesses a highly active opposition ecosystem that, frankly, simply doesn't tolerate those lazy assumptions. When a foreign brand fails here, they rarely fail because the Indian consumer rejected their product. They fail because they didn't respect the environment they were entering. But while we completely agree on the fundamental Tejswi IP philosophy that India rewards preparation and severely punishes assumption, I think we're going to clash today on where the primary vulnerability actually lies for these entering entities.
Well, we usually do. We're looking at the exact same structural failures across the board, but we're prioritizing the threats differently. My position, based on the legal frameworks we construct and defend here, is that structural and procedural omissions are the most critical, fatal flaws. I'm talking specifically about a failure to understand the procedural cadence of Indian courts, assuming enforcement timelines will mirror those in the United States, and completely neglecting ongoing structural requirements like patent working disclosures. These are the bedrock architectural failures that collapse a brand's legal foundation from the inside out.
Procedural compliance is undeniably important, I'll give you that, but you're prioritizing the long-game paperwork over the immediate ambush. The most aggressive and immediate exposures come directly from local market opportunism and cultural nuances. I'm focusing on the active opposition ecosystem, local distributors making bad faith filings, opportunistic third parties, and the incredibly complex reality of phonetic trademark overlaps across India's vast linguistic landscape. In my view, foreign brands are far more likely to be ensnared by the opportunistic actions of local actors before your procedural paperwork errors even have a chance to matter.
I see the logic there, I really do. But it falls apart when you look at the systemic nature of these failures. Let's step into the mechanics of the procedural side for a moment. When a foreign brand treats complex legal architecture as simple paperwork, they create a systemic vulnerability that no amount of clever market strategy can fix. The most glaring example is the assumption that litigation strategies mirror the United States. Indian courts are highly sophisticated, but their cadence is completely different. If you walk into an Indian court expecting a rapid, US-style preliminary injunction without having built the precise evidentiary architecture required under Indian law, you're going to hit a brick wall.
Hold on. Let's break that down for our listeners who aren't in the courtroom every day. When you talk about the evidentiary architecture for an injunction, what exactly are these brands failing to provide?
Mostly, they fail to secure an ex parte ad interim injunction. To put it simply, that's an emergency stop order. It's when a judge agrees to halt a local competitor's infringing sales immediately, even before that competitor has a chance to present their side of the story in court. To get that in India, you have to prove a prima facie case, meaning, at first glance, your evidence is overwhelmingly airtight. You also have to prove balance of convenience, showing that if the judge doesn't freeze operations, you suffer vastly more damage than the competitor would. And finally, irreparable harm, proving that money alone won't fix the damage later. Foreign brands often show up with weak, generalized evidence that might fly in a US discovery phase, but in India, the judge denies the emergency stop order. Once denied, your commercial operations are stalled indefinitely, while the local infringer keeps selling.
You're outlining a very real judicial hurdle. Absolutely. But again, you're looking at the courtroom while the house is burning down on the street. Before a brand even gets to draft a plea for an interim injunction, they have to survive the local distributors. Let me give you a scenario we see constantly at Tejswi IP. A massive U.S. fitness equipment brand decides to enter India. They send a few emails to a prominent Indian distributor to explore a partnership. They share their pitch decks, their branding, their timelines. The distributor says, "We'll review this and get back to you." The very next morning, that distributor files the foreign brand's trademark under their own name in the Indian registry.
Right, which is a classic bad faith filing.
Exactly. It's a hostage situation. A year later, the U.S. brand tries to launch only to receive a cease and desist letter from their own former contact. The local distributor does this to secure leverage. They force the foreign brand to either buy back their own intellectual property at an extortionate premium, or they demand an exclusive distribution agreement on highly unfavorable terms. This active opposition culture is aggressive. It's immediate. And here's the kicker. It requires absolutely zero technical sophistication from the bad faith actor. It just requires opportunism. Overcoming this halts commercial momentum instantly.
I don't disagree that distributor extortion happens. It's a massive headache. But I'd argue that if a brand engages in distributor discussions before securing their foundational intellectual property architecture in India, they have already committed a procedural error. That is treating IP as an afterthought rather than a prerequisite. It's a failure of sequencing. But let's look at a procedural failure that you cannot simply buy your way out of. Patent working statements. India uniquely requires periodic disclosure of your patent working status through what's known as Form 27.
Right. The requirement to actually prove you are using the patent locally.
Precisely. For those unfamiliar, a patent working statement is essentially you proving to the Indian government that you are actually manufacturing or licensing your invention locally for the benefit of the public, not just sitting on the patent to block competitors. This isn't a one-and-done filing. It is a continuous structural obligation. If a German manufacturing firm gets a patent for a revolutionary valve but ignores Form 27 because their home jurisdiction doesn't require it, they introduce an irreversible vulnerability. An Indian competitor can monitor that noncompliance, petition the government, and demand a compulsory license.
Meaning the government steps in and forces the German firm to let the Indian competitor manufacture the valve?
Exactly. Suddenly, the foreign brand's core technological advantage is stripped away and legally handed to a local rival because of a missed form. You cannot retroactively fix years of non-disclosure. Trademark extortion delays you, but systemic non-compliance with patent working statements destroys you. That procedural omission strikes at the very heart of the asset's validity.
That's a very textbook perspective on the catastrophic nature of patents. But the reality on the ground is different. To reach the stage where a compulsory license on a patent is your biggest problem, you must have successfully entered the market, established a presence, and maintained operations for years. I am arguing that local market opportunism stops these brands at the gate. Let's pivot to the trademark side, specifically the linguistic traps. You mentioned earlier that trademark extortion merely delays you. I think you're vastly underestimating how fatal a delay can be in modern commerce.
I'm not minimizing the commercial impact of a delayed launch. It's expensive. But Indian law provides clear mechanisms for rectification and cancellation of marks filed in bad faith. It's manageable.
Manageable is a dangerous word when millions of dollars in supply chain logistics are ticking away. Let's talk about phonetic equivalence. Standard trademark clearance is often an illusion of safety. Foreign brands typically only run clearance checks for identical marks in English. They completely ignore the vast reality of phonetic equivalence across India's incredibly diverse, multilingual landscape. We have 22 official languages. Let's say a European audio tech brand called Vayu wants to enter the market. They check the English registry, all clear. They manufacture packaging, they ship inventory, they launch the marketing campaign.
And then they get hit with an opposition from a regional player.
Exactly. They get hit with an opposition because a local company in Maharashtra has a phonetically identical mark registered in the Devanagari script for a similar class of electronics. The local company claims consumer confusion in that specific, massive regional market. The foreign brand didn't even know it existed because their clearance was a literal English translation check, not a phonetic mapping exercise. It isn't just a legal hurdle. It is a commercial roadblock that drains capital and destroys market timing.
Rectification might be theoretically possible, but practically, it forces the foreign entity into years of litigation before they can sell a single speaker.
You make a great point about the complexity of the linguistic landscape. The fact that similarity analysis must consider phonetic equivalents across multiple languages is exactly why we insist on deep clearance at Tejswi IP. But let's take your analogy of looking at the courtroom versus looking at the street. I want to look at the timeline of entry, specifically the delay in national phase entry for patents, because the opportunism you're talking about isn't limited to trademarks. It happens in the patent space too, and it's far more sophisticated.
You're talking about the Patent Cooperation Treaty window.
Yes. Let's break down the PCT for a second. Think of the Patent Cooperation Treaty as a global reservation system. A foreign corporation files an international patent application. They essentially book a table, giving them a specific window, typically 31 months, to actually show up and enter the national phase in India to claim their specific rights here. If they delay this entry until month 30 without conducting rigorous local competitor mapping, they are flying blind.
And you're arguing that local competitors are using that 31-month window to actively build against them.
They absolutely are. During that window, local Indian competitors aren't sitting idle. They're studying the published international applications. Let's say it's a pharmaceutical compound. The foreign grant patents the core active ingredient. The local Indian company reads the publication and immediately files incremental patents. They patent a specific, highly efficient, cheaper manufacturing process for that exact ingredient. Think of it like buying a plot of land to build a house, but waiting 2 years to build the road to get there. By the time you do, your competitors have bought up all the land around you and you're entirely fenced in. We call this a patent thicket. By the time the foreign brand finally enters the Indian national phase, they find their operational freedom heavily constrained. They can't manufacture efficiently without paying royalties to the local entity who structurally outmaneuvered them through the procedural system.
That is a highly sophisticated strategy, and it certainly happens in the pharma and heavy tech sectors. But look at what you just described. You're trying to frame it as a procedural failure by the foreign brand. But the actual threat, the thing causing the damage, is the active, aggressive opportunism of the local Indian competitor. You're acknowledging that the local players are highly adept at weaponizing the very procedural systems you're defending.
They can only weaponize the system if the foreign brand leaves a gap in their procedural armor. If the foreign brand had executed early competitor mapping and filed their national phase applications without resting on the 31-month buffer, that local opportunism would have no oxygen.
I don't disagree that closing the gap is the goal, but let's bring this back to your earlier point about navigating the Indian legal system, specifically the interim injunctions. You mentioned that failing to secure that emergency stop order means bleeding out over 5 years of litigation. Who actually benefits from that procedural reality?
The infringing party, obviously.
Exactly. The active opposition ecosystem. The very sophistication and deliberate cadence of the Indian legal system is exactly what empowers these local entities. It makes it easier for bad faith actors to drag foreign brands into lengthy rectification processes. If a local distributor files a bad faith mark, they know full well that the foreign brands will have to navigate this complex interim relief landscape. They don't file the mark because they think they have a legitimate legal right to it. They file it to use the procedural system as a weapon of attrition.
A war of attrition.
Precisely. The procedural complexity you are highlighting is exactly why local, cultural, and market opportunism is so dangerous. A local bad faith actor doesn't need to win the case on the merits 5 years down the line. They just need to survive that initial interim stage and let the procedural cadence bleed the foreign brand of its commercial resolve until the brand settles and pays the ransom.
That's a fascinating way to frame the procedural system as a tool for the opportunistic actor, but it merely underscores the absolute necessity of my argument. Robust, flawless legal architecture is the only viable defense. You can't change the opportunistic culture of a massive, competitive emerging market. You can only control your structural readiness. If the brand had executed comprehensive phonetic trademark clearance up front, if they had filed their national phase patents without delay and tracked the competitors' thickets, and if they maintained flawless patent working statements, the local actor would have zero leverage to exploit in court. The sophistication of the Indian courts ultimately protects the prepared and exposes the presumptuous.
Preparation is absolutely the shield. However, I maintain that you cannot build a truly resilient legal architecture without first deeply understanding the local culture that is going to attack it. You can file all the paperwork perfectly according to some standardized international playbook. But if you don't understand how Hindi phonetics overlap with English branding in the minds of a local consumer base, or how local distribution networks share information to anticipate your entry, your perfect paperwork isn't going to save you. The true traps are linguistic and behavioral, not merely administrative. When we advise clients at Tejswi IP, we have to force them to look beyond the identical mark search. We have to make them realize that the opposition they will face is not a glitch in the system. It is a built-in feature of a highly competitive, fast-moving local economy.
It is clear we are circling a unified truth from two different angles. We are looking at a market that is fundamentally uncompromising when it comes to intellectual property diligence. Let me summarize my position in light of our back and forth today. The foundation of a foreign brand's success in India rests on recognizing that legal architecture is not just administrative paperwork. The most critical, fatal vulnerabilities arise when companies fail to respect the procedural rigor of this specific jurisdiction. Delaying national phase entry without mapping local competitors allows rivals to build patent thickets that constrain your operational freedom. Failing to strictly comply with uniquely Indian requirements, like the continuous disclosure of patent working status through Form 27, creates a systemic vulnerability that invalidates your core assets entirely. And above all, assuming that Indian enforcement timelines and litigation strategies mirror the United States ensures catastrophic failure at the crucial interim relief stage. Rigorous procedural compliance is the only way to build a resilient, defensible position in this market.
And my summary is that while that procedural architecture is obviously necessary, it is entirely insufficient if it turns a blind eye to the realities of the local environment. Mastering the local opposition culture is the true key to avoiding catastrophic exposure. A brand must understand that a standard English identical mark clearance is an absolute illusion of safety in a country with multiple official languages and vast phonetic overlaps. They must proactively guard against the immense, immediate threat of bad faith filings by local distributors and opportunistic third parties who actively monitor and anticipate their entry. The procedural sophistication of Indian courts is indeed a reality, but it is a reality that local actors are highly adept at weaponizing to stall commercial momentum. Therefore, understanding the aggressive, anticipatory nature of the Indian market is the primary imperative before a single form is ever filed.
While we may prioritize the threats differently, whether the fatal blow ultimately comes from a procedural omission deep in the patent registry or a localized bad faith attack on the ground, we converge completely on the core philosophy that drives our work here at Tejswi IP. If a foreign entity enters India without structured clearance across trademarks, patents, and potential cultural oppositions, their subsequent exposure isn't a matter of bad luck.
Not at all. It's a direct consequence of treating a complex legal and cultural architecture as a simple checklist.
Exactly. India is an environment that substantially rewards meticulous preparation, and it severely punishes assumption. There is so much more to explore regarding these strategies, from the specifics of phonetic mapping to the granular nuances of securing those ad interim injunctions.
Indeed, the intricacies of this market require constant vigilance and a profound respect for both the written law and the unwritten market dynamics.
Thanks for listening. Stay tuned for more upcoming episodes and...
For reliable and expert intellectual property legal services, contact Tejswi IP today. Our team of experienced attorneys is dedicated to helping individuals and businesses safeguard their intellectual property rights in the digital age.